name on here going, and then I will go ahead and turn it over to you, John.
All right, thank you very much. Can everybody hear me? Okie dokie. So thanks so much for inviting me to this, and I hope everybody's having a great Tuesday afternoon. As you can see from my window here, the sun's come out, so we're in a good mood here at McMahon Burger. Again, my name's John Marino. I am a labor and employment defense attorney at McMahon Burger here in St. Louis. So what I do is I defend companies, public entities, schools, all kinds of different entities from employment discrimination lawsuits, and I do a lot of union negotiations and things like that. So the presentation I was asked to give today is an update on the status of Missouri marijuana and touching a little bit on federal marijuana issues from an employment law perspective. So what employers are thinking as they're going through and evaluating and dealing with the challenges of the recreational legalization of marijuana that took place last November. So the presentation you're going to see here is a presentation that I've given several times to a lot of employers. Obviously, I've changed some things to impact our audience that hopefully are relevant for you. But this is a subject that I've been speaking on for a number of years. So if you have questions, please feel free to shout them out. Or Amy, I think you're going to be monitoring the chat. And don't hesitate to interrupt me during the presentation. If you have a question about a slide, I'm sure somebody else might have that same question. So you're not throwing me off if you have a question. Let's answer them when they come up. And of course, we can take questions at the end as well. And also, I will have these slides available to you all. So there's going to be some that might look a little dense, but don't worry, you will have these as reference materials later on. So if you miss something, don't worry about taking copious notes or anything like that. We'll make sure you have access to all these things. So without further ado, I'll start sharing my slides. And just so everyone knows, we're going to kind of touch on big picture, federal, and then we're going to kind of narrow it down to Missouri, state issues, and then specific employment, employer-related issues is kind of how this presentation is set up. So let me share my slides, and if somebody could tell me if this works, we'll be in good shape. All right, how's that looking? All righty, see a thumbs up. Okay, marijuana in the workplace is where we're at right now. And if it looks like I'm not looking at the camera, I apologize. I have my dual screen set up right now, so I'm kind of looking at both. So Missouri marijuana in the workplace. So here's where we stand now. Just big picture, fully legal in 21 states and medically legal in 37 states. You have a couple states that have decriminalized but not officially legalized, and we'll talk about the difference here in a second between legalization and decriminalization. And one of the running factors you'll see throughout this presentation is kind of the impact on local and state economies. Here you can see you've got over 450,000 people working in the marijuana industry now. Yeah, if I were to venture to guess, that number well exceeds 500,000 at this stage. There's a lot of people working in marijuana these days. It's become a big industry. There's a lot of money in marijuana, which is why you're kind of seeing the rapid evolution of legalization here over the past several years. And where does the public stand on this? This has been something that's been kind of fascinating to kind of track over the past 5 or 10 years. So now just 1 in 10 U.S. adults say marijuana should not be legal at all. About 60% think it should be legal, recreational and medicinally, as we see in Missouri. 30% say medical only. And then again, of course, 10% think it shouldn't be legal at all. And you're starting to see these numbers shift and shift and shift and get more and more people who are in favor of it legal medicinally and recreationally. So these numbers have evolved really, frankly, pretty rapidly. And Missouri has been pretty much online with these numbers as it comes to how the votes have passed, specifically the ballot initiative that passed last November. I think it was right at around 55, 56%, which is pretty close to that national kind of average you're seeing. So here's the state summary, and this is where I list all these just as a point of reference of kind of where each state is at. And they're in here alphabetically, and you can see here I've got several slides. So don't worry about scrambling or writing these down. Again, I'm going to make these slides available to you. I just wanted to have the information in these materials so you could all see them. And we'll skip ahead here to kind of illegal versus decriminalization. I'm sure you maybe glanced at this, and I mentioned this just a few seconds ago. Some states have, decriminalized it versus making it totally legal, lawful. So what illegal means is not allowed. It's totally unlawful. But where you see some states decriminalize it, essentially means they've made it kind of a misdemeanor. They've made it like a minor traffic violation. There's going to be no arrest, prison time, or criminal record for first-time possession based on the amounts and things like that. So even states that have not fully legalized marijuana, either medicinally or recreationally, some of them, and you've seen this a lot in municipalities, have decriminalized it to the extent the municipalities can. And that's something that you see is really a larger trend in employment law, is that, not to get on my soapbox here of how you see employment laws change, in that a lot of within the past 10 or 15 years, employment laws are kind of driven from the bottom up, where you have local municipalities or states making changes to employment laws because there's not been much progress at a federal level, and you haven't seen any major federal legislation passed from an employment law perspective really since FMLA, which was passed in 1993. We had the Americans with Disabilities Act amendments in 2008, but there has not been major employment law legislation at a federal level in a number of years. That's about 30 years. This year was the 30th anniversary of FMLA. So as a result of that, you have a lot of municipalities and states kind of taking the mantle up themselves to pass employment law. And the same can be said for marijuana. I know we saw some decriminalization at a local level in, I believe, Columbia, Missouri, Springfield, Missouri over the past 10 years before it became legal medicinally and recreationally here in Missouri. Expungents, and also another word that you're seeing a lot of or hearing a lot of when it comes to some of these legalization statutes at a state level. So why are you seeing the push for expungement? And it's really a twofold issue. You have social justice, the Black Lives Matter movement. There's been a big push for social justice in that the number of people incarcerated, specifically African American males, for marijuana possession is significantly higher than any other groups. And you're also seeing labor market. Obviously, since 2020, this country has been dealing with a significant labor shortage that frankly has been on the horizon for a number of years, given the baby boomer generation easing into retirement and the change, frankly, of what we call work here in this country with the advent of hybrid work and things like that. So there's a lack of workers. So you're seeing a lot of states kind of push for expungement, A, for social justice, and B, from a labor market perspective, because they know employers look at background tests and background information and background checks prior to employment. So if they can expunge crimes that they now consider minor, specifically marijuana, drug-related convictions, nonviolent marijuana-related convictions, they're going to do that to increase the labor market. And how does this affect employers? Again, criminal records are no longer going to include convictions for serious crimes. Marijuana is often considered a gateway drug. It's indicative of other drug use. However, that's kind of a misconception that's slowly starting to kind of ease away. But these are all things for employers to consider. So the expungement piece is really a piece to make it easier for employers to hire people that maybe had a previous conviction that would have otherwise kept them out of the workforce. Again, why do you see the effect of legalization? A lot of this is the states are kind of coming, you're kind of hitting the Malcolm Gladwell proverbial tipping point here. When it comes to states that are legalizing it. Frankly, they don't want to miss the boat on the revenue increases. I know Missouri has seen, and we'll talk about these numbers here in a second, significant revenues and income based on legalization of recreational marijuana. I remember just 2 years ago when Oklahoma passed recreational marijuana, they had I think they took in about 80 million revenue in the first 6 months just in taxes alone. And it also is considered, especially for those red states, those Midwestern states, those agri states that have a big focus on agribusiness. It introduces a new industry into the state with additional jobs. You saw first under President Obama and later under President Trump, where hemp products were first allowed under the Farm Act to be insured products. So you had a lot of farmers who didn't traditionally even contemplate growing a product like hemp, which is a derivative of marijuana, but doesn't have the drug effects, if you will, of marijuana, but has a variety of other uses. You started to see, because farmers could now get crop insurance under the farm bills that I believe passed in 2018 and 2020, we're able to now get crop insurance that to diversify the types of crops a lot of these Midwest farmers are able to grow. But of course, a lot of problems that come with it. This is a lot of my clients are dealing with now. How do you maintain a safe workplace? How do you deal with insurance? How do you deal with drug testing? All of these issues that you're now facing, especially coupled with what you're seeing with the labor shortage and other issues in the workplace. It's become a very, very complicated issue, and it's been something we've spent a lot of time with here at McMahon Berger. So let's talk a little bit about federal marijuana laws because they're kind of all over the place. So here's where we're at now, is that cannabis is still illegal under federal law, and it's a Schedule I narcotic under the Controlled Substances Act. So it's the highest level. It's considered the most dangerous type of narcotic. However, just recently, the Health and Human Services at a federal level has recommended be rescheduled in the 2024 regulations. And you have President Biden, who's so far come out and said he supports that. It remains to be seen if that is going to be actually descheduled as that moves forward into the next year. Transporting and selling cannabis is, of course, because federal laws is across state lines is prohibited. And then the big thing that is, especially from an industry standpoint, a lot of some of the early state movers on the recreational medicinal marijuana had trouble, having financial institutions that could handle their transactions. I know in Oregon they actually built a separate treasury because a lot of the dispensaries were just coming up to pay their taxes with duffel bags full of cash, not an exaggeration, because they had tax bills and they couldn't find a bank that would handle their money because the industry they're in, because banks are worried about losing their federal deposit insurance. So they were paying taxes in cash. It was a significant issue. But you're starting to see some of these things erode away as we kind of move through federal marijuana laws. So there's a bunch of different laws kind of at play here that kind of address different issues. And some of the big ones that have been kind of pending and proposed over the past several years are kind of still hanging out there. So we're just going to hit the highlights of this before we get into the specific Missouri aspects. So there's the Cannabis Administration Opportunity Act, which would very simply remove marijuana from the federal banned substance list, address criminal justice and societal issues, proposes a federal marijuana tax, and with the intent of saying, states are the ones reaping the tax benefit now. The federal government wants to get in on this and do broad-based federal legalization. Then there's the MORE Act, which I believe was proposed originally by Cory Booker, removes marijuana from the Federal Controlled Substances Act, but it also does additional things with respect to social justice, such as expungement, pathways for ownership for minority business owners, does some things for veterans, removes the threat of deportation, and also provides for reinvestment opportunities in communities that have been adversely affected by marijuana laws that have been in place for the past 30, 40, 50 years. So those are kind of the two major kind of competing pieces of legislation that we have. What's the difference between the two is taxes is a big one. National sales tax rate under MORE is 5%, gradually increased into 8%. Under the CAO Act nationwide, 10% rising to 25% over years. And that is frankly something that has caused significant pause. The tax rates, especially because once the tax rates become high enough, you still allow a black market to thrive. That's an issue that it's been, I believe, faced in California with their high tax rates, in that because the taxes are so high, a black market still exists for this, and enforcement becomes a little bit trickier when it comes to. So that's kind of the mark against the higher taxes when it comes to these things. And again, pushes for expungement in both the social justice and labor market issues, as we discussed previously. Another piece of legislation that's pretty recent is under Senator Hickenlooper is the Preparing Regulators Effectively for a Post-Prohibition Adult Use Regulated Environment, PREPARE Act. I love the acronyms that we come up with at the federal level. If only we spend as much time on our legislation as we did with coming up with clever acronyms. All this does is direct the Attorney General to develop a framework for cannabis regulation. Essentially, it's a bill that says, hey, Attorney General, do something because we think this is coming. That's all that PREPARE Act does. And then more recently, and perhaps more significantly than it's given credit for, is the Safe Banking Act. And this is kind of the first time we've seen bipartisan support and potentially movement to the Senate floor for a full vote. So what this essentially would allow is for marijuana businesses to use major financial and banking institutions. So allow them to use, Bank of America, US Bank, Commerce Bank, whatever bank you use locally, which is a significant deal for treating them like they're legitimate businesses, because there's still, frankly, that dichotomy right now in that it's legal at a state level, but it's still illegal at a federal level. So these are legitimate businesses in states like Missouri, but how do they conduct businesses like all the other businesses? Because when you think about it, you know, not to get too much into constitutional law, but the Commerce Clause in interstate commerce, requires a very low threshold for you to be considered an interstate commerce, which I would venture to guess a lot of these institutions are tangentially involved in interstate commerce. So getting a Safe Banking Act, allowing them access to the same financial institutions that any other business has, would be a big deal and a big domino to fall when it comes to federal marijuana legalization. And of course, the other big X factor here, as we kind of narrow it down into things that employers are concerned about, is the Americans with Disabilities Act. So the ADA right now doesn't consider individuals who currently use illegal drugs to be qualified as disabled individuals. So what that means is that marijuana is still illegal federally, and Americans with Disabilities Act, the ADA, is a federal law. Now, where you see some interesting thing in here, and I don't want to get too much into the weeds, but some of the first states to legalize marijuana, the states that we all think in our head as kind of the leaders on the marijuana front, California, Oregon, Colorado, they didn't have a specific carve out provision under the ADA. So you weren't protected under these state laws for medical marijuana use. Later states, kind of the East Coast states that kind of followed suit after California, Oregon, and Colorado, learned from this and did carve out specific prohibitions against discriminating against people who had a lawfully held medical marijuana card. So when Missouri first passed their medical marijuana law, they did not have a carve out. So you could technically discriminate against somebody for having a medical marijuana card. You didn't have to accommodate them, things like that. That has since changed since we've passed recreational marijuana. And that's been really the big change for a lot of employers. Kind of one of the things that was not discussed as much as just the broad headline of marijuana is now legal in Missouri was the fact that you can no longer discriminate against people in Missouri for having a medical marijuana card. It's treated just like any other disability. So with that being kind of the very, very, very high overview of where we're at federally, let's talk about Missouri marijuana and what things have transpired. And again, we're going to talk about this and kind of give you a general overview of Missouri, what's kind of transpired. We're about a month away. We're 11 months into having legal recreational marijuana here. And then we're going to kind of narrow it down to talk about some of the things that I discuss with my clients from policy standpoint, a drug testing standpoint. So again, recreational marijuana became legal in Missouri on December 8, 2022. Began accepting applications for medical dispensaries on December 8, 2022. I think we started selling marijuana recreationally legal in February 2023. And at this point, we're selling about $4 million worth of marijuana per day. We'll have sold easily probably $2 billion worth of marijuana since 2020. And they're expecting a huge growth rate between now and 2030. And you've got about 16,000 cannabis-related jobs. And that's only expected to increase over the next several years as this market grows. You're really seeing a kind of a market explosion right now. And it remains to be seen. These are still mostly local owned companies. It remains to be seen what happens once this does go legal federally, because I think that's where we're going. I think everybody kind of sees the writing on the wall. It's just a matter of how we're going to get there, when we're going to get there, what's going to happen to kind of these local businesses once you have large national players at play that can own different entities across different states, at least more explicitly than they do now. So again, Missouri's marijuana law, and this is the big change that kind of passed that was part of the ballot initiative from last November. Employers cannot discriminate against employees for holding a valid medical marijuana card. That prohibition doesn't apply if there's a federal contractor involved, if you're under the influence at work, assuming the employer has a policy, which is a big thing we talk about with my clients, is making sure you have a drug-free workplace policy. That the individual tests positive for marijuana and the employer establishes they used, possessed, or went under the influence on the employer's premises during working hours, which that seems pretty straightforward, but it's really not, because the big issue with marijuana testing, unlike other drugs, there's no way to test for current impairment. That's the big difficulty with marijuana testing, and that's why you're seeing so many challenges for employers in the workplace. And individual holds a position that the use of marijuana affects in any manner their ability to safely perform their job responsibilities, essentially a safety exclusion for discriminating against people who maybe have a medical marijuana card. Again, safety sensitive employees. Safety sensitive position is one where the employee holding this position has the responsibility for his, her own safety or other people's safety. That does usually include the safety of pieces of equipment, significant pieces of equipment. Safety sensitive is one of those terms that in the course of my 20 years of doing this in employment law, when I first started doing this, you had a lot of employers trying to basically say everything was safety sensitive, like a bank teller safety sensitive. Well, you want your bank teller, they're dealing with your money to be safe, so that's a safety sensitive position. It's kind of been drawn back a little bit to actually be what it was originally intended to be, which is, again, responsible for a person or others' physical well-being as well as, the safety of highly expensive property and things like that. The other exceptions are federal contractors and recipients of federal grants who must comply with the Federal Drug-Free Workplace Act. There's no protections, again, for recreational marijuana use. And that's the thing. We did see kind of I want to say the number of medical marijuana cards is still in the tens of thousands, not in the hundreds of thousands. So we saw a kind of an initial burst of people applying for medical marijuana cards, but really not to the extent you thought you might see it in that first 2 years. And now obviously we have recreational marijuana. So to what extent do people feel the need to go get diagnosed with something to actually get a medical marijuana card? I don't think we've seen quite the increase we thought we were going to see in medical marijuana cards. So it maybe not has been as much of an issue that we thought it was going to be. But regardless, employers can prohibit employees from using, buying, selling on the premises, or working under the influence of marijuana. That's not changed. Even if you have a medical marijuana card, the employer can still prevent you from being under the influence at work. You can discipline, terminate, or refuse to hire employees based on recreational marijuana use. Nothing there has changed. And employers are still allowed to require drug testing. And really the big thing here, and what I've spent a lot of time over the past several months is because you don't have the ability to test for current impairment. So if somebody gets into an accident at work and you send them off to get a drug test and they test positive for marijuana, that drug test doesn't tell you anything. All that drug test tells you is that at some point, probably within the past 30 days, that person has used marijuana. There's no way to actually determine if they are under the influence while at work, or alternatively, or stated another way, if they were under the influence of marijuana at work and it was a proximate cause of whatever incident they were involved in at work. So a lot of what we've been talking to our clients about is training managers on things like recognizing marijuana intoxication and kind of developing that reasonable suspicion testing. So what reasonable suspicion testing is, you don't necessarily have to get into an accident or something at work, but if you appear under the influence, if you smell like marijuana, if your performance is going down, or anything like that, where it looks like you're on drugs, for lack of a better way to describe that, the employer has the ability, if they have this policy in place, to send you out for what's called reasonable suspicion testing. So we've spent some time over the past year, kind of training some of our clients and their managers on how to identify, how to go through reasonable suspicion training so they can identify employees who might be under the influence at work. That, coupled with a positive drug test, and again, it remains to be seen, but might be sufficient, arguably, to demonstrate that somebody is under the influence at work. If you have those two things, A, the observing of the behavior, and B, a positive drug test, that might be enough to show that somebody's under the influence at work. But again, we have a law that's been in place for 11 months, so a lot of the applications of these things, have yet to make their way through the court system, and it's probably going to be another couple of years before we find out how courts are going to interpret these things to say where's the burden lie on demonstrating somebody is under the influence to justify a termination. A little bit more on Missouri's marijuana law: no public consumption, micro licensing is permitted, limited marketing, you must be over 21, and some basic kind of requirements that similar to what you see with alcohol sales. No driving under the influence. Police officers are getting trained on being able to to detect or identify if somebody may be under the influence of marijuana. But again, police officers are going to face the same challenges employers are going to face, in that there's no way to determine if someone's currently impaired under marijuana use. But under the law, they have the ability to call in an expert, and they're going to have training to identify, whether or not they think somebody might be under the influence. Zoning, and this is interesting, I serve on the Chesterfield Planning Zoning Commission. We've actually spent some time discussing on this. Municipalities can regulate time, place, and manner of dispensaries, and they can force dispensaries to be over 1,000 feet from schools, unless the municipality decides they allow it to be less than that. They could hypothetically ban sales, but that's only through a citizen referendum. So I have not seen that yet. I think the law is too new to see any municipality actually take that as a citizen referendum. And then, of course, taxing. Municipalities can add another 3% tax, as well as counties, to the current Missouri marijuana laws. So let's get into what's a Missouri employer to do. This is what we talk to a lot of our clients about, because they've got federal issues they're dealing with, state issues, drug testing, policy concerns, and then, frankly, just the basics of how to maintain a productive workforce. So that's, kind of the big issues that the employers are facing. So the first thing we always talk to our clients about is, you need to have a good policy in place, that prohibits the use of illegal drugs or other controlled substances while you're at work or while you're using company vehicles. Of course, that covers prescription medications as well, and prohibit people from being under the influence at work. A lot of policies, a policy that every employer should have. Don't be on drugs or alcohol or under the influence while you're at work. Pretty simple. But that's a big thing that we encourage a lot of employers to kind of revisit. And then they need to kind of make a decision on how you're going to handle drug testing. 10 years ago, a lot of employers were engaged in pre-employment drug screening. It was worth the cost for them. They could filter out candidates based on drug screening when they had made somebody an offer of employment. But you've seen, especially in light of the labor shortage, a lot of employers kind of roll back their drug testing. A, they don't want to pay for it, and B, they realize that, hey, my pool of potential applicants is decreasing significantly because I have a pre-employment drug screen. Now you have some of our clients and some businesses, depending on their industry, of course, safety sensitive positions like truck drivers, things like that, schools, teachers, whatnot, they're still going to do a pre-employment drug screen. But a lot of employers kind of rolled it back and say, hey, we still want to do a pre-employment drug screen, but we really don't care about marijuana. So we're going to do one of these panel tests, but we're going to specifically exclude marijuana. And my advice to them is always, okay, well, Lynn, for your pre-employment drug screening policy that you're going to have somebody sign off and say, I'm going to go to XYZ clinic to get drug tested, list the drugs you're going to test for, and specifically don't include marijuana or cannabinoids under that, and make sure that they're not testing for it, because that's a big thing. We kind of mentioned this before we get started here, is as an employer, you get presented with the drug testing facilities that give you the 10 panel or 12 panel, whatever tests. There's no one test for all the drugs. It's all a bunch of different tests. This is how it's marketed as what we're going to be testing for. So make sure it's excluded if you're not going to test for marijuana, or you don't want marijuana results from a HIPAA standpoint, that you don't get them, you don't test for them. The other type of testing that you see is reasonable suspicion testing. We kind of mentioned that. And a lot of states have different definition, but basically it means is, can you observe, do you have neutral observations that somebody's under the influence at work? You've got random drug testing, which is a little more rare these days. Random drug testing, typically you see in safety sensitive positions and things like DOT positions, truck drivers and whatnot. And typically a random drug test is done by a third party. And that would be my advice to a client, is have a third party administer and select specifically the people who are going to be engaging in the random drug testing. That way there's no potential for discrimination and whatnot. That way a third party is the one randomly choosing people to get drug tested. And then post-accident testing. So I drive my forklift into a wall at work or something, or I do whatever at work and I get hurt, you automatically send people out for post-accident testing. The trick with this one, a lot of employers face is, not every workplace incident is some major incident where somebody's damaging property or hurting themselves. A lot of times it's a smaller incident, or maybe it doesn't result in a workers' comp claim until a few days later when the injury actually manifests itself, especially when it comes to soft tissue injuries. So if you have post-accident, if you have post-accident testing, the trick with this one is to ensure that you're doing it consistently. But again, the big issue here is there's no current technology that can detect the levels of intoxication with cannabis. And it's very hard to prove if somebody's under the influence at work. That's why you want to kind of couple it with reasonable suspicion training, because so much of this stuff depends on, frequency of use, what your body chemistry looks like, what your metabolism looks like, your height, your weight, all these different things that go into how long marijuana is detectable in your system. I was at the SHRM National Conference. I serve on the president-elect for Missouri SHRM, which is the Society for Human Resources Management, and the former president of SHRM St. Louis. And I was at the SHRM National Conference in Las Vegas this year with the specific intent of wandering around the massive Las Vegas Convention Center to where the business people are, and seeing where they were selling their wares and talking to all the drug testing people to see, have you come up with a current impairment test, or is this in the works for you? And I was not optimistic that this is anything that's going to be coming to light anytime soon. If anybody on this Zoom call decides they can invent a current impairment testing, I am available to your general counsel, because you're going to make about $1 billion in about a month, because this is one of those things that there is a huge need for. I know they're studying it, but at this point, I don't see it being on the horizon. And even when it does come, if in fact it does come at some point, it's going to be like when flat screen TVs came out. It's going to be so, the cost is going to be so high initially, it's going to take several years for that market to come down, where everyday employers, your regular businesses, can even be able to afford to test for reasonable suspicion testing. Again, more and more employers are treating marijuana like alcohol, and they're kind of indifferent to recreational use as long as people are off duty and they're not under the influence at work. So what does a positive test means? Again, this is kind of specifics of how the testing works. Doesn't mean individuals high or under the influence or impaired at the time of the test. So that's kind of the trick. So that's why you couple it with a reasonable suspicion observation, because a positive drug test, all that tells you is that somebody was under the influence or somebody used marijuana within the past 30 days. It doesn't tell you whether or not they were under the influence at the time of the accident. So you want to have, most employers want to have a really well-written policy, and they want to ensure that there's other kind of caveats in there, like reasonable suspicion training and things like that. Confidentiality is a big piece of this, making sure that things are maintained confidentiality, and you treat it like it's like you're obtaining personal medical information from your employees. That's a big piece that we want to make sure a lot of our employers stay abreast of. And again, reconsidering the pre-employment drug screening. I think this is a topic that you all probably have some questions out down the road here, or in a few minutes here. But whether or not we have a policy, making sure we're consistently enforcing it, and do you need one? Or is it a safety sensitive? Is it a DOT position? Is there licensing requirements? What does your workers' comp carrier say about it? Do you require it in order to maintain lower workers' comp standards? These are all different factors that employers are considering right now when it comes to what kind of pre-employment drug screening we want to do. And then, of course, post-employment drug testing. How are we going to treat these things for random? How are we going to treat these things for post-accident testing? Again, current impairment, that's the biggest issue we face with marijuana right now. And then there's the workers' comp aspects of it, because if you have a policy in place and you can prove that somebody's under the influence and it was a proximate cause of their accident, you're going to reduce somebody's potential workers' comp recovery down to zero, which is a big deal under Missouri law, and it reduces the exposure for a lot of employers. So there's a lot of factors at play here, and I'll stop sharing my screen because I imagine we have questions. There we go. So kind of a 30-minute overview of where we're at from a marijuana standpoint, federally and at a state level. But this is something that, is continuing to evolve. And, we still get questions on very, very, very often, on probably a weekly basis, on how to handle these things. But I'd like to open up the floor for questions, because I know we have a lot of participants here and there's probably some things you all were wondering. So I'm going to pause for a second and take a sip of coffee. Does anybody have any questions?
Please feel free to unmute yourself if you have a question, or you can put it in the chat. So I'm guessing, John, do employers need to take really good notes, I guess, if they're under the suspicion that somebody is?
So, what I like with a reasonable suspicion, because let's be honest, let's be practical about how we think about this. The person who is observing somebody who's potentially under the influence is probably going to be one of their direct reports, right? And so, potentially there's other issues there with, how long that person's worked there, whatever other issues. So I always think it's good to get double confirmation. So you get somebody that's observing one of their direct reports, and then they get somebody from a different, if it's possible at all, depending on the company, from a different kind of department. You know, if you have a security officer or you have a human resources officer or some other department to say, hey, can you go, you know, watch Amy for a few minutes and see if you notice anything suspicious about how she's acting, or observe her, or go talk to her, something like that. And then that way you have one supervisor who says, yes, I noticed this, and I engaged Amy to make a determination to see if this person was under the influence. And then Amy writes a report as, I noticed the smell of marijuana, I noticed that this person seemed lethargic, whatever it is. And then you've got double confirmation of reasonable suspicion, coupled with, presumably, if you send them for a drug test, a positive drug screen, then you can say, we had these neutral observations, 2 people neutrally confirmed it, they had a positive drug test as well, we made a determination they were under the influence of work because of these 2 things.
And if they have a medical marijuana card, that doesn't cover them with the ADA.
And that's a big thing, because if you have a medical marijuana card, that's a question, is because you still can prohibit people from being under the influence at work, even if you have a medical marijuana card. But it requires the person to disclose that they actually have a medical marijuana card. So that therein lies the rub with some of these things, is that, did you have knowledge that the person had a medical marijuana card? Because if not, there's no way to accommodate. You're not discriminating against them based on a disability if you had no idea somebody had a medical marijuana card. And if they come forward and say, you know, after a reasonable suspicion test, and then a reasonable suspicion confirmation by a supervisor, then a positive drug test, and then they come forward and say, well, I have a medical marijuana card. Well, maybe the burden becomes a little bit higher and you call up your friendly labor and employment attorney to talk about it, but that still doesn't prevent you from enforcing discipline for somebody who was under the influence of work, or you suspect was under the influence of work. The other thing too is here that a lot of people forget, because you got to think of this mindset. Like, we've been dealing with drugs and the war on drugs for so long, we've kind of put them all in one bucket when it comes to how we treat marijuana versus cocaine and methamphetamines and all these other things. But there's nothing to say that you can't discriminate based on the type of drugs that people use. So if I have an employee that tests positive for marijuana, I can treat them differently from an employee who tests positive for methamphetamines. I can say, well, you tested positive for marijuana, so I'm just going to give you a write-up, or I'm going to suspend you, whatever. I'm going to send you home for the day, and then you come back to work, and I'll give you another drug test in a week, and if you come up clean, you're fine. And if somebody tests positive for methamphetamines, you could say, no, I'm going to terminate based on this because you tested positive for this. So you can treat these things differently. There's nothing to say that you have to treat all drugs equally. You can discriminate based on type of drug use.
So would you recommend that if they have a medical marijuana card, they're upfront with that?
I would think so, because they are offered certain protections in the workplace. You know, and I get that that can be something, because again, you're talking about a big paradigm shift that we're kind of in the middle of right now. I would say if you know, and it's very, and it's hard to say this, I think you get legal protections if you disclose that you have a medical marijuana card at the outset. You also are going to be calling suspicion on yourself. And there's still I still have some clients, some employers who very much have a traditional view of drug use. And I've had clients call me and say, I was interviewing an applicant, they disclosed they had a medical marijuana card, and I don't want to hire them because they had a medical marijuana card, you know? So that, you know, I don't want to commit one way or the other on it, but you are, under the law, afforded accommodation provisions, at least under state law, for having a medical marijuana card.
So if they've already been offered the job, they couldn't rescind it because they had that card.
I would, if I'm advising a client and they've made a job offer to somebody who then disclosed, because they're about to go get sent for a pre-employment drug screen, and they disclose, hey, I have a medical marijuana card, so I might test positive for marijuana, I would have a hard time telling that employer to rescind that job offer unless they had another valid reason for it, or if they had some reason it was a safety sensitive position where there was no way they could not be under the influence. It would be very difficult to rescind that job offer in that situation. in my opinion.
We do have some.
None of this should be construed as legal advice, by the way. These are all very fact-intensive situations, but I'm speaking very broad strokes. I should say that caveat there.
Yes, take every piece individually. So if you go seek legal advice for individual clients. So we did have a statement. Starlet says, I get so many clients saying they can't pass a drug test, but say they won't be doing drugs at work. We get that a lot.
Yeah. So they can't pass a drug test, but they're not going to be doing drugs. I mean, and that's, you know, and that's, you know, it depends kind of on, you know, because it all depends on the approach of the employer, because whether some employer or not is going to actually disclose in the application process, hey, are you willing to take a drug screen? You will probably, they'll tell you that question if you make it to the interview process, or if you make it to a pre-employment, you know, to an offer of employment. But a lot of employers, you know, have kind of gotten away from saying, hey, we're going to drug test you, and they just kind of put it on you. Hey, are you willing to consent to a drug test? And I certainly understand that concern, but employers still do have the right to test for drugs and can rescind job offers based on positive drug tests or refusal to take a drug test pre-employment. But it's slowly starting to change when it comes to the use of marijuana. Not necessarily other drugs, but you're starting to get a lot of employers, you know, treat marijuana, like we said in the slides, you know, like alcohol, and not be as concerned about it. But it's very, very individualized depending on what employer you're dealing with, what industry you're dealing with.
I'm guessing if federally it becomes legal, it's going to be a whole new ballgame.
Yeah, and then of course, the Federal Drug Free, you know, Workplace Act, that's a whole nother issue when it comes to federal. Any employer that gets a federal grant, you know, is going to have a federal drug-free workplace policy, and that's a whole different animal when it comes to, they don't want to jeopardize potential federal contracts by having a loosey-goosey drug testing policy.
We did have a question from Tom, and Tom, I don't know if you want to jump in and make this more specific, but he says, are there any rules regarding agencies or vendors complying with marijuana use rules set forth by our business partners?
I don't think so, as long as it's not discriminatory. You know, you can, you know, because you can discriminate based on recreational marijuana use. But where I would caution having a policy is where you're discriminating against potentially people who have medical marijuana, because that all of a sudden becomes disability discrimination. But having a policy that says we don't want our agencies or vendors to have anybody under the influence while they're at work, or, you know, while they're performing work on our behalf or whatever, you know, I think that's totally fine. But you do need to be aware that, you know, again, medical marijuana is to treat disabilities. So there is a potential for disability discrimination if you're just doing a blanket, you know, you can't use marijuana, period, kind of thing. You know, you need to be specific on how you word that. You know, and that can be built into a drug-free workplace policy, or a separate policy, or something you build in with your agency or your vendor contract to ensure that people remain not on the influence of drugs while they're performing work or present at your facility. It's a good question, though.
So he says, so if some Acme widget company has a strict drug policy, and they have job coaches going in to help a client learn that job, how does that work? Like, does the drug policy at the company they're going into affect them too, or just the business they're coming from?
You know, it's going to depend on the specific vendor agreement, and those are going to be very specific as to, you know, if I'm bringing people in to that extent where they're training people, you know, so you're allowing them access to not only your facility but also your employees. I'm going to have a vendor contract where I'm going to spell all that stuff out, and says that we are a drug-free workplace policy, and, you know, please provide us, or please ensure that the coaches you provide us are not under the influence, and whatever other requirements you might require for them to ensure that they're not under the influence at work. But that can be something that you negotiate in a contract with them, or a vendor contract, or if you're an agency or an entity that deals with vendors on a frequent basis, might be something you might want to build into your boilerplate contract, depending on your level of concern. But again, same ADA issues live there, you know, because you don't want to discriminate against people with a disability. But I think it's very safe to say that we expect everybody to be, you cannot be under the influence while you're at work. Now, where that becomes a little bit trickier is how do you demand that a vendor drug test somebody if you do have the suspicion? Because I would not imagine, unless you had a very specific contract, which I've never seen before, that you could send a vendor out for drug testing. I don't even think that would be feasible. Especially, just given the complexities with that.
Yeah.
Well, that's a good question.
Starla asked, is there a drug test that can only detect medical pot within a day or so of use?
I wish, Starla, I wish there was. But that would be close to a current impairment testing. No, there's not. There's no way to, there's not. Because, how I'm, 6'2", 210, how does my body metabolize, cannabinoids versus somebody who's, 5'2", 110 pounds? You know what I mean? It's all very different. There's, it's very, I went to my doctor because I was so curious about this. And we are still learning biologically how the cannabinoid system, engages in how all this stuff works. But there's not, because so much of that, Starla, is contingent on your internal metabolism in your body. There's just no way to do it. I wish there was, but that would essentially be a current impairment test.
Carrie wants to know, can you give a bit more clarification on businesses or companies that receive federal funds, such as medical facilities that receive Medicare, how that works?
Yes, I can, but that is a whole different presentation on Medicare and whether or not those people are considered federal contractors. I've been down that road before, and it's not a simple answer, and there's no clean answer that I can give in the course of this presentation, Carrie. So I would encourage you to contact your local or your labor and employment attorney who you utilize for those issues, because I've looked into it before for other clients, and there's not a simple answer to that one. Because whether or not Medicare or Medicaid is considered federal funds, that's a great question, and there's no clean answer to that. I would say that just receiving those funds arguably is not being considered a federal contractor. But again, don't construe any of this as legal advice, because I don't know who you work for and what your entity is and what you all do. But there's a lot there. That's a great question, and that's a question that's probably beyond the scope of what we're talking about here. Or excuse me, deeper than the scope we're talking about here, but that's a great question.
My point goes along with at Voc Rehab, we receive federal funding too, so we cannot help a client get a job where they're, working at a medical marijuana dispensary. I mean, just because it's still illegal federally. So.
Yep. And you're going to see this stuff change at a federal level. You might see a change as early as 2024 if they change the control, the schedule, if it's considered still a Schedule I drug. And it's really kind of a fascinating issue because, I've spent years looking over the stuff, because you have constitutional law issues, you have state law issues, you have federal issues, you have all kinds of different things at play here that cover a whole different host of areas of law, and impact whole different areas of, our state's economies beyond just, drug testing, but the actual businesses themselves. So it's really a fascinating issue, and it's evolving very, 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 very quickly. And we're just waiting to see if the feds catch up to some of these things, and it'll be interesting to see what happens with it. I think.
Can I, so
Yep.
as just a little bit of follow up with that. So like, there's a lot of places that receive federal funds, minus like Medicare or, health insurance or whatever. But, even, child care providers and, will receive grants from the federal government. Does that fall underneath the federal stuff at all, or is that still in the trying to figure out what's federal funds and what's not kind of type of thing?
Yeah, I mean, it's going to be very fact specific, and I'm not comfortable answering that question based on not, it depends entirely on the types of federal funds you're getting. If you're getting federal
Okay.
grants, that's one thing. If you're a federal contractor, that's another thing. You know what I mean? So I think
Okay.
if you're a federal contractor, you're obviously going to fall under that. But if you're just
Right.
receiving federal funds, it very well might not. But at this point,
Oh,
I'm not comfortable saying whether or not, because it depends on, what types of funds you're receiving, how you're receiving them, what the grant process looks like, all these other things
okay.
potentially
Gotcha.
apply here.
Okay. Awesome. Thank you.
You guys are really trying to pin me down on that federal funds question. I'm not going to take the bait. I'm not going to do it.
Good for you. Yeah. We come across that a lot.
I know it, and I've dealt with it before, and it's very sticky, and I hate to give you a non-answer on it, but trust
Yeah,
me,
that helps.
as much as I love this talking to everybody here, you don't want to take your advice from me based on hey, we do kind of do this. You want to that's an issue you're gonna want to do a deep dive on, and it's going to be contingent on all kinds of different factors of the types of funds you're receiving, what the grant looks like, whether you're a contractor, whether you're just receiving, what types, if you're a
Right.
contractor, you're receiving grants, all these things are at play here. Um, it's a complicated issue.
No, awesome. That actually helps a lot. Thank you.
And Kevin has a question. Do you have guidance for counselors or teachers working with youth using marijuana and how it might impact their employment options and career choices for the future?
Well, yeah, I mean, absolutely, because it's you know employers can still test for marijuana, and it could very well limit your employment opportunities moving forward, depending on what type of job you want to do and what type of industry you want to be engaged in. Um, they need to be people need to be cognizant of that. Students need to be cognizant of that and understand that decisions they make when it comes to drug use very well could have an impact on the types of industries they're going to be able to find gainful employment in, for sure. Um, I don't know if that, there's not just because recreational marijuana is the law of the land doesn't give you a free pass to use marijuana and not have any consequences for it when it comes to, your employment. People still and employers still will continue for the foreseeable future, as much as I like to say, treat it like alcohol. A lot of employers aren't. They're going to treat it like it's an illegal drug, which it is still an illegal drug at a federal level. So just because it's legal recreationally doesn't mean you get a free pass and that there's no consequences or that nobody can discriminate against you for it unless you have a medical marijuana card. Like just saying, well, what do you mean? I tested positive for this drug, and what do you mean you're not going to give me a job anymore? Well, they can still prohibit. That's using marijuana is not a protected class. It's not, protected by Title VII or the ADA, of course, unless you have a medical marijuana card, or the Age Discrimination Employment Act is not one of these laws that have discrimination protection. I can discriminate against people for wearing purple shirts. I can discriminate against people for, drinking Bud Light over Budweiser. I can discriminate against people, I can put that as an employment. Do you drink Bud Light or Budweiser? Well, I drink Bud Light. Okay, well, you're not hired because I only hire Bud Light. You can discriminate based on these things as long as it's not a protected class. So long as they don't have a medical marijuana card, an employer can choose to discriminate based on drug use or not drug use. So there's absolutely consequences for it. Just because it's legal recreationally doesn't mean employers have to hire everybody.
I think we see that a lot of people think that because it has become legal recreationally that you can do whatever you want.
Yeah, that's not how it works. Here's a question. Would a person need to be over 21 to obtain a medical marijuana card? It's a good question. I think that's a yes. But I want to go back and look at I think that's a yes on that one. I know it's recreational for sure.
That could be somebody who has epilepsy who.
Yeah, and you know what? Maybe that's not true because I actually know, when the first thing that passed for marijuana, it's not marijuana, so we'll call it CDs, cannabinoid related products, was in Missouri gosh, this is probably a decade ago, was the hemp oil. Because I actually had a friend who was the lobbyist, whose daughter had epilepsy, and they actually moved to Colorado because she was having like 20 or 30 seizures a day. They moved to Colorado because they had access to the hemp oil there, which reduced her seizures from like 20 something a day to less than one a day. He was a big lobbyist in Missouri to get that passed. And I want to say that was 10 years ago because there's only 2 facilities in Missouri that actually produce it. And yeah, that usage had to have been was a child, so it had to have been over 21. That's an interesting question. I feel embarrassed that I don't know that. So now I want to say, at least I know that hemp oil one. If it's prescribed, I think the idea is a medical provider can prescribe whatever they think is going to help somebody with their medical condition. So maybe I'll withdraw yeah, you have to be over 21 based on that. That was a great hint that you just gave me, Amy, on the hemp oil thing. I forgot about that. We forget about where this all started. That was the first domino to fall a while ago.
Well, somebody just posted that guardians can get a medical card for their kids for it,
Yeah.
potentially. So
Yeah, and I guess I would have presumed that's like any other medical provider. You still have to present your child to the medical provider. Now, I don't know where your kids go to the doctor. I don't think, it's been weird with the medical marijuana cards because you saw, I haven't looked at the numbers recently. And you saw an initial uptick of, okay, people are going to apply for these cards. Then it kind of tapered off. It didn't become the numbers people thought it was. And maybe that's because everybody kind of realized recreational was on the horizon pretty quickly thereafter. So there wasn't some rush to get medical marijuana cards. Because what I don't see, I'd be curious. My kids were at the doctor for their back to school stuff a month or two ago. And I didn't ask him. I should have asked him, would you prescribe my kid marijuana if you wanted to? I highly doubt it, because most of the practitioners who are prescribing it, just based on their traditional kind of medical school training, aren't going to prescribe medical marijuana because there's still a lot of criticism of it from a medical use standpoint, especially out of the traditional medical community. There's also, from my very limited understanding of this, and some of you can probably speak to this better than I can, a distinct acknowledgement that there's a lack of understanding of how it interacts and how the cannabinoid system, which is part of our bodies, impacts the rest of our health and all these other things. And there's an acknowledgement that we don't know a lot of these things. So it's kind of fascinating. Much like diet nutrition has not been something traditionally taught in medical schools, and you're starting to see a change in that people start to realize the impact that has on people's day-to-day lives. We're starting to get more and more kind of research on these various issues. But the medical field might be the one field that moves slower than the legal field. Slow. Good value add, though. Guardians and parents can get a medical card for their kid. Good value add. Nobody get any clever ideas there. I know we can't joke. I shouldn't joke about it yet, but I can joke a little bit because I have kids. There is sometimes I tranquilize them. Don't tell them I said that, though.
Does anybody have any other questions? This has been fantastic information.
Well, I appreciate you all letting me come and speak to you. It's an interesting topic. Like I said, it covers a whole host of different issues in areas of law, so it's interesting for me. As much as I love being known as the drug guy at my office, that's certainly where I've spent a lot of time looking into these issues because it is very fascinating, and it's going to continue to change. You're going to see updates, and maybe I'll come back next year and give you a federal update depending on how these things are happening. And maybe we'll see more of an application. It's going to be a couple of years before we see this kind of, how the courts interpret some of these things. And the other thing I will say is that, the way the law was passed as a ballot initiative, as a constitutional amendment, that's tough, because that makes it a lot harder for us as a state to kind of evolve and have the marijuana laws evolve, the regulations evolve, because now it's a part of our Constitution, much like casinos. Casinos are part of the Missouri Constitution, which is, to some extent, you look at it as like, oh, this has been good for our state from a tax revenue standpoint. But the mechanism by which we passed it through a constitutional ballot initiative will make it harder for us in the future to be more nimble in addressing it and adjusting it based on the needs of the state. So that's a little bit of a soapbox from a legislative position that nobody cares about, but it's interesting. Sorry. Nerding out on marijuana laws.
You've gotten lots of thank yous. And again, a question if the presentation materials will be available. So I don't know if you can email me that.
Yeah, I'm gonna
Yes.
save them as a PDF and I'll email them to you as soon as we log off here.
That would be amazing.
All right.
All right. Thank you
All right.
so much.
Thanks, everybody. Have a good one.
You.